So on the 400th episode of my channel, 400th video on my YouTube channel about data privacy, well, for sure, I am not going to tell you any history about how it all started. What I want to talk about is try to explain you the key requirements of DPDP Act 2023 for any business in India. Welcome to my YouTube channel where you have been watching new content on data privacy for 400 days now, and we are going to talk about the DPDP Act 2023 explained within 10 minutes. Key components. Does the DPDP Act matter? DPDP Act matters a lot. Why does it really matter? We've been talking of digitization and putting everything digital. But everything digital does not mean only convenience. And to get that convenience, whatever is available, you need to make a lot of effort. You need to provide your personal information to the application that you are going to use. It could be a grocery, it could be buying airline tickets, any kind of online shopping that you are doing would have your personal details. Apart from being digital, you should also remember that even in the non digital world today, there's a lot of almost all shopkeepers in your locality must be delivering things at home. So you need to share with them your address and phone number, the bare minimum and the most important basic personal information. Apps we were talking of, they include aggregators, grocery shop, you place an order and on the online app, and they might be delivering it from different grocery stores around you. It actually started with that, and of course for that they'll share data with them. Apart from that, what about the delivery guys? Are they their employees, the grocery shop's employees, or even a third party? So that means your personal information in terms of your address and phone number is now getting shared with another one, another item. Now, with so many people involved in the entire chain, misuse of your personal information is definitely possible. People may not realize the relevance, right? So, you need to regulate this information, sharing of this information, usage of this information, so that you don't feel cheated. You don't feel that your information is being misused. And to do that, and to make the organizations processing this personal information more accountable, there has to be a law. There has to be an act that has been enacted. Final rules are yet expected, so that should be enforced anytime from now. We are in July 2025 right now. The core principle of DPDP Act, it's your personal information, your data, it's your control. How do you want to use it is your control. I gave you these examples. Even in these examples, one side is that if you want the service, you need to give me the address. Second side is check on my website. Where am I going to use your address? And if you are okay with that, share your address, share your phone number, share your email ID, share your banking information, right? You are going to make payments in any case. So the data would get collected by your permission, processed by your permission, shared and deleted with your permission, shared with, in this particular case, with the perhaps the third party courier agency who is going to deliver the goods at your home, and delete it finally, like even this act says for e-commerce companies. If a customer has not been active for 3 years, delete their personal information, right? Everything is going to happen with your permission. You are now the boss of your personal information. If you see anyone skipping any of these steps, then you can fight for it. It's a punishable offense now. Who does this apply to? It applies to any business who processes digital form of personal information of any citizen of India. Data is processed in digital form, might have been collected manually and digitized later. It's very, very critical and more important for sensitive personal information like your financial information, for your healthcare information, and it is important that the permission taken should also be noted. There has to be an evidence that you have collected the information or processed the information with permission. Secure it, both the consents, the logs, and the personal information with proper security norms. It's all digital, so it's all IT from that point of view. Key definitions introduced in the Act, data principles. The people, the individual whose personal information is being processed, the customers, data fiduciaries, the organization who are collecting and processing the information. By the way, when the word processing applies, it applies to collecting, using, sharing, storing, and deleting personal information in digital format of any citizen of India. It becomes significant data fiduciary with additional responsibilities of getting assessments done, DPIA done, and taking more ownership of the personal data that they have collected when it is sensitive personal data, and we call them as significant data fiduciaries. Data processors, the part of the organization of fiduciary, internal or external, who are going to process this information, and consent managers, who are going to act as the collectors of permission for processing this information. Key obligations of the fiduciaries: they need to define the purpose why they are collecting the information, which has to be very clear. Consent needs to be obtained. Collect whatever information required, but only what is required and no extra information, only for the purpose that you have defined, and use it also only for the purpose, right? You might say, I have another service that I can provide with the same information, but unless you take consent again for the other service, you cannot process this information. Obtain the consent before processing the information. Respect the user rights. We are going to touch base on them as well in the next slide. And follow the security protocols while collecting and storing this information, which includes role-based access controls, control or access only to people who are involved in processing, and privacy enhancement techniques like encryption or encryption and anonymization. Follow the retention rules. You need to define with your purpose. I need this data for this purpose for this period. And therefore, at the end of the period, I'll delete it. Maintain logs and evidence of each and every activity that we have spoken of in this slide. User rights. User has the right to access his personal information. User has the right to get his personal information corrected. Revoke the consent, and these need to be granular. You provide me 10 services, you need 10 consents. I may withdraw consent from one or two services. Deletion of the information is again user right. He might come back and say, I don't want you to even keep my information. I have revoked the consent. Fine, so now you don't even have the consent to process my information, but I want you to delete it also, and he has the right to get that done. And a complete proper grievance addressal mechanism that says if the user is not satisfied, if the data principal is not satisfied, how would the fiduciary behave and take his complaint seriously. Then we come to consent management. The aggregator, the software, the service provider as per DPDP Act, who is going to collect consent on your behalf from the various data principals. They'll maintain the record of the consents they have, and they have to have, and therefore you have to have, it falls under fiduciary's responsibility, a log of all the consents that you have taken, when, what purpose, when were they withdrawn, if at all withdrawn, when were they revoked, if it was a minor, did you take parental consent, if it was disabled, did you take the guardian's consent, what if the child has now become major, so then you need a reconsent. So everything is to be logged and maintained by a consent management authority appointed or registered with Data Protection Board of India or the Ministry of Electronics and Information Technology. Data Protection Board of India is yet to be formed. It would be once the law is enacted. Consent has to be free, with clear purpose, unambiguous, revocable, centralized, unified with consent IDs, which can be common to the various services or business units within the organization. They've recently launched the guidelines under the business requirement document. The Ministry of Electronics and IT has done that. I have a complete playlist on that. You can see what guidelines they have provided with respect to the consent management, registry certifications, so that consent management is not misused, and maintain the complete life cycle of the consent: obtained, used, revoked, deleted. And maintenance means you have logs of each and every stage. Other key points that have been brought in the Act as well as the DPDP rules that came in 2025: fiduciaries should publish a proper privacy notice indicating how they are going to use the information. Consent recommendations are there in the BRD document, so you can refer to that. Breach notification timelines have been brought in. What if a breach happens? In what time frame would that be notified? Implement privacy by design principles. Again, I have a complete playlist and different multiple videos on privacy by design. The Dr. Ann Kowukian's model on how privacy is to be maintained. So, implement privacy by design principles, and there's a complete detail on the penalties if in case you create a problem for anyone, which means if you don't have consent, if the information has been breached, if the information has been misused. Penalties can go up to 200 to 250 crores. Maybe the first offense is not taken that seriously, but you have to be very, very careful. So that's about the quick brief on the DPDP Act 2023. The video has gone slightly beyond 10 minutes away from its title, but I'm sure it has good information about the Act. Please subscribe to my channel, and if you like this video, please press the bell and the like icon and share your feedback in the comment section. Thank you.